Did you know that small and medium-sized enterprises represent 99% of all businesses in the EU and account for 70% of all jobs? Close to 45% of GDP in the EU was generated by IPR-intensive industries. SMEs are the motor of the EU economy. Their potential to boost employment and drive future innovation, two key priorities for the European Union, should not be overlooked. SMEs are particularly present in innovative industries such as clean technologies, healthcare, ICT, etc. Today, more and more SMEs are looking for business opportunities in emerging markets. Many of those companies are considering China, Southeast Asia, and Latin America as potential destinations. Trade relations between the EU and emerging markets have taken a new turn with the ongoing negotiation of FTAs and investment agreements. These regions are attractive destinations for European investors, with their fast-growing markets, rising middle classes, and competitiveness. Due to limited resources and available capacity, SMEs face many difficulties in managing their IP assets, and particularly when this involves IPR infringement in other regions. Intangible assets such as intellectual property rights are key factors in the competitiveness of businesses in the global economy. We have to be aware that IPR-intensive industries contributed 86% of imports and 93% of exports to EU external trade. And in developing markets such as Southeast Asia, Latin American countries and China, your trademark, patent, trade secret, industrial design are endangered. Before internationalizing your business, take an active part in protecting your assets. The International IPR SME help desks are here to assist you and contribute to SMEs' internationalization by the provision of step-by-step advice to build a successful IPR strategy for entering into the Chinese, Southeast Asian and/or Latin American markets. The range of services offered by the help desk includes a 24-hour helpline service to reply to IPR questions, free online and on-site trainings delivered by IPR experts, free publications on various IPR topics and country fact sheets, and other useful information forms such as case studies, e-learning modules, video podcasts, and more. So if you have any inquiries on IP protection, contact the help desk in China, SEA, or Latin America to learn how to manage your IP assets and expand your business successfully.
Developing the Creative Economy and Intellectual Property Perspective is organized by the European Chamber of Commerce of the Philippines, the ECCP Intellectual Property Committee, and Southeast Asia IP SME Help Desk.
We would like to acknowledge our corporate partners,
as well as our premium members. Here are some gentle reminders before you officially start the webinar. The moderator will allot time for a question and answer portion. Please use the Q&A box in your Zoom platform if you have any questions. No other recordings are allowed once you enter the webinar. Copyright 2022, all rights reserved to ECCP.
Okay, good afternoon, everyone. Happy World IP Month. A very warm welcome to all of you. My name is Divina Ilas Panganiban, and I chair the IP Rights Committee of the ECCP. I'm delighted to be your master of ceremonies for today's session on developing the creative economy and intellectual property perspective. This is organized by the ECCP's Intellectual Property Committee and the Southeast Asia IP SME Help Desk. I would like to take this opportunity to thank everyone for making this event possible, our esteemed speakers, whom we are about to hear from later in the program, and our attendees for joining us physically and tuning in with us virtually. Before we proceed to the program, please allow me to reiterate some health and safety reminders to our physical attendees. Please keep your face masks worn properly as necessary in the duration of the program. We also highly encourage our participants to limit close physical contact as much as possible. As acknowledged upon registration for this event, the ECCP event organizers will not be held liable for any loss, damage, illness, or injury that may be sustained in your participation in the activity while in or around the premises or while using the facilities. So, moving on, it's my honor to introduce our first keynote speaker for today. To provide us with updates on the Philippine intellectual property landscape, and joining us physically is Attorney Emerson G. Puyo, Director 4 of the Bureau of Copyright and Other Related Rights of the Intellectual Property Office of the Philippines. Attorney Emer has more than 20 years of professional experience in both the government and the private sector, serving in various capacities ranging from technical, supervisory, and as part of top management. Notably, Attorney Emer is the first director of the Bureau of Copyrights, which was constituted only recently. In a nutshell, the Bureau accepts, reviews, and decides on applications for accreditation of collective management organizations, conducts studies and researches in the field of copyright and related rights, and exercises original jurisdiction relating to the terms of a license involving the author's right to public performance or communication of his works. Attorney Emer holds a Bachelor of Laws degree and is an active member of the local bar association. He has a master's degree in business administration and an undergraduate degree in social sciences, double major in economics and political science. It's our pleasure to have you with us today, Attorney Emer. You may now proceed with your presentation.
Thank you very much, Attorney Vina. Thank you very much, and good afternoon to all participants in this afternoon's webinar. I have been tasked to give you an update on the Philippine intellectual property landscape. Just as a sort of a disclaimer that I will actually be discussing more in the area of copyright and related rights, since it is the work of the Bureau, which I currently head, and also because copyright and related rights would be the closest connection to our creative industries. So, to give you an update on the Philippine intellectual property landscape, I would be discussing updates in terms of the 4 pillars of our Philippine intellectual property system. The first one would be on the legal framework. What have been the developments in terms of the legal framework, and what are the current challenges in terms of the legal framework? Secondly, I will be discussing updates in terms of rights management before proceeding to enforcement of rights. And finally, to discussing about the different support infrastructure that are available for our creatives and for our authors and creators. So let me proceed with updates and challenges for the legal framework. What you see here in the slide is a development of our Philippine copyright law, as well as our accession to various international treaties and agreements. Starting in 1950 with our accession to the Berne Convention for the protection of literary and artistic works. Formally, our copyright law started with the Spanish copyright law, followed by Act 3134, and in 1972 with the promulgation of Presidential Decree number 49. In more modern times, of course, we have the passing of Republic Act 18093 in 1998 as formerly known as the Intellectual Property Code of the Philippines. And then we acceded to both the White WPPT and the Marrakesh Treaty in 2002 and in 2018. Of course, in 2013, there was, as you know, Republic Act number 10372, which amended to a great extent much of our copyright law, and in fact was the law that created the Bureau of Copyright and Related Rights. So in this slide, the update would be the Marrakesh Treaty, our accession to the Marrakesh Treaty, which is a limitation and exception in favor of our visually impaired, blind, and visually impaired persons as an exception to copyright. And more recently, last year, the Philippines also acceded to the Beijing Treaty on Audiovisual Performances. So this is a piece of an international agreement that would benefit our actors or our performers in the audiovisual industry or the film and audiovisual industry. So if you look actually at our law is quite comprehensive, but you would be surprised that there are still certain changes that are desired to this comprehensive piece of law. Among the features of our Philippine copyright law are the following: economic and moral rights, including resale rights for our visual artists, is included, but we follow the minimum term of protection provided under applicable international agreements, which is 50 years. We, however, observe a voluntary system of copyright registration, which the National Library and the Intellectual Property Office, as deputized by the National Library, also accepts registration of copyright and related rights. Our law provides for criminal, civil, and administrative remedies for copyright infringement, and an accreditation system for collective rights management. And finally, it incorporates both the fair use and fair dealing traditions of other jurisdictions. Fair use you'd find, for example, in the US, fair dealing would be more prominent in the European Union, and UK, for example. So in terms of challenges and ongoing updates, I think in the next few years, we will see an expansion in the coverage and scope of copyright protection. Presently, in the upcoming meeting of the World Intellectual Property Organization Standing Committee on Copyright and Related Rights, some pieces of items in the agenda would be the Broadcasting Organizations Treaty, which is in the area of related rights. Of course, you have the proposal for a stage director's rights and the formal adoption of a possible international instrument on resale rights. Right now, there are certain jurisdictions, which includes the Philippines, that has a resale right, but there is no international instrument on resale rights. And there are even discussions on public lending rights, as this particular discussion is, of course, borne by the experience during the pandemic. So that's the first update. Those are certain things that we expect to see in the next couple of years. Of course, in terms of technological developments as affecting our copyright law and copyright principles, we have developments such as the debate on artificial intelligence, on whether or not works, literary and artistic works created by artificial intelligence should be afforded copyright protection. We also have the ongoing debate on databases and also exceptions and limitations relating to data and text mining. And of course, you've heard in the last couple of years the now popular non-fungible tokens or NFTs and crypto art. So we have to be at the forefront of study and research as to how this impacts on copyright and related rights. And lastly, of course, we are a social media uh, avid social media users. We have social media and user generated contents. And this is important, especially in the Philippines, and I think in most of Southeast Asia, because, because as you see, our population is about 50% of the Philippine population are between the ages of 10 to 65 or more. I think that's about 60% are in the ages 10 to 65. And we, of course, know that this young generation are really into the digital content creations. Next. Stop working. Okay. So in terms of our copyright law, there is a need to have implementing rules and regulations for certain portions of the copyright law that are yet to be drafted. For example, compulsory licensing schemes are largely unexplored, which is part of the debate, especially during the time of the pandemic and emergency situations like the pandemic. Of course, as you noted, there can be expansion of protected works. And lastly, it's really ripe for amendment and a comprehensive review of our copyright law. In terms of rights management, which is the second pillar of our copyright system, we all know, just as a background, that you can exercise your copyright individually, or you may opt to have a collective management of rights. In the Philippines, as a background, the basis for collective rights management is provided in Section 183 of our Intellectual Property Code, which provides that the owners of copyright and related rights or their heirs may designate a society of artists, writers, composers, and other rights holders to collectively manage their economic or moral rights on their behalf. For the said societies to enforce the rights of their members, they shall first secure the necessary accreditation from the Intellectual Property Office. To implement this particular provision of the law, in 2020, we have issued IPOPHL Memorandum Circular number 2020-026, which provides for the revised rules and regulations on the accreditation of collective management organizations. The said circular provides for the procedures, the requirements for accreditation, the rights and duties of an accredited collective management organization, and lastly, it provides also for post-accreditation actions and transactions such as cancellation or perhaps suspension of the accreditation of a collective management organization based on certain grounds. So to give you an idea of the collective rights management system in the Philippines, In the area of copyright, we have two collective management organizations. One would be PhilSCAP, or the Filipino Society of Composers, Authors, and Publishers. The rights holders involved are music composers, authors, and publishers. So very active. Recently, PhilSCAP is very active now, especially with the use of songs and musical compositions during the campaign period. Of course, their administered third rights are public performance rights, and the validity of their accreditation is until February 20 of next year. So that's the logo of PhilSCAP. And in the area of text and image sector, we have the Filipinas Copyright Licensing Society, or PhilCols. So if you need to get permission and to secure a license as regards reproduction rights of the composition or of the works of authors and publishers, you need to approach PhilCols with an accreditation valid until January 19, 2023. In the area of related rights or neighboring rights, we have more accredited collective management organization. One is PRSP, which represents performers both in sound recordings, or your singers, and audiovisual works, or you call them your actors. So they administer both exclusive rights and remuneration rights, and validity of accreditation is until 2026. The longer period of accreditation is one of the updates in terms of accreditation of collective management organizations. From 3 years, the validity of accreditation is now 5 years. Independent music producers of the Philippines, or IMPRO, which represents independent music producers or sound recording producers, with accreditation until 2026. PRM is a unique animal in the sense that it's the first joint collective management organization of sound performers and sound recording producers in the Philippines, and its accreditation is valid until June 6, 2026. And our most recent accredited CMO in the area of neighboring rights would be the Sound Recording Rights Society, with accreditation valid until March 6, 2027. So given that, I think it's not working again. Sorry. Yeah. Another update is that we actually released last year an advisory to the public on unaccredited collective management organization. Basically, we announced to the public who the accredited collective management organizations are and what are the consequences, or warning the public against dealing with unaccredited collective management organizations. So what are the challenges? And these are ongoing updates, I believe, in terms of rights management. We need to see the accreditation of more collective management organizations. Not that more is desired, but I think it's important that major sectors in the copyright industry and creative industry should be represented by collective management organizations. In the film and audiovisual, for example, in the performing arts, in design, graphic and visual arts, and software. So we'd be happy if there are more organizations, particularly representing key sectors or industries within the copyright sector. We, of course, would have to have continuing discourse on collective rights management, topics such as a one-stop shop for music, because you noted that there are already 4 CMOs in just music-related copyright and related rights alone. And of course, there is the issue of collective licensing. And of course, there is a need also to balance the rights, which means protecting the users and the general public from what perhaps they may perceive as excesses of collective management organization. And this will be addressed by being stricter in terms of enforcing transparency, accountability, and good governance among collective management organization. Let's now go to enforcement of rights, which is the third pillar. As you know, the IP code provides for these remedies: a civil remedy, a criminal remedy, which the first two are filed before the courts. And of course, there is the administrative remedy, which is sought before the Bureau of Legal Affairs of the Intellectual Property Office of the Philippines. I put there an asterisk because the IPOPHIL also has an IP Enforcement Office to carry out the visitorial powers of the Director General. It is concurrently the Secretariat of the National Committee on Intellectual Property Rights Enforcement, or NCIPR, which is a grouping or committee of 12 agencies of government involved in IP enforcement. Okay, so IPOPHIL has been very aggressive in making sure that we run after pirates and counterfeiters. In 2021, as this news article would tell you, IPOPHIL-led NCIPR registered the biggest seizure of 24.6 billion counterfeit goods in 2021. Just more recently, in April of this year, NCIPR members, including the NBI, seized 63 million counterfeits in one of the notorious malls, Green Hills, where you have counterfeit products. The IPOPHIL engages in this with the help of netizens, which are reportedly pushing for counterfeiting and piracy reports to a new high. And we also do this in partnership, our enforcement functions, in partnership with various industry associations, such as the Motion Picture Association, the Japan's leading anti-piracy group, and even Philippine Retailers Association, in order to stamp out counterfeiting and piracy, especially in the retail industry. And of course, we call on national and even local government units to institutionalize policies against counterfeiting and piracy. Okay. So those are all the efforts that IPOPHIL has been doing in terms of IPR enforcement. Let's now go to the last pillar, which is infrastructure support. For infrastructure support, we note that there are at least 3 ongoing mapping and road mapping projects on the creative industry. There are various creative industry-related bills and legislative proposals. I am sure that one of our speakers, Congressman Toff, who is a staunch advocate of the creative industry, will be discussing later on about these creative industry-related bills and legislative proposals. And of course, there are ongoing initiatives of various cultural and development agencies in the area of copyright. The Bureau of Copyright and Related Rights was created under 10372, as I said. Our functions are this. And we would like to just share with you, as part of the update in the landscape, that our Bureau is now fully manned with 3 divisions addressing the various needs of the creative sector, from accreditation of collective management to the Creative Sector Development Division, and lastly to Copyright Services Division, which includes our voluntary system of copyright registration. So in terms of our awareness, we're doing the following things. In terms of traditional approach with a twist. We actually have small group discussions or consultations wherein you are able to consult with our Bureau of Copyright and Related Rights lawyers on your copyright-related inquiries and concerns. We have also published several reference materials on copyright, starting with the Copyright Reference Book. These are all available, by the way, at the IPOPHIL website. And since the second half of last year, we have been publishing the Copyright Bulletin, which is our way of reaching out to our stakeholders to be able to discuss with them copyright-related issues such as technology and copyright. And more recently, this year, our first issue for Volume 2 would be copyright and public domain as the main theme of discussion. Also, in November of last year, we held the first Philippine International Copyright Summit, where we had over 2.5 million of viewers and internet traffic. We had, we had around 68 sessions on discussing topics about copyright and related rights, with 24 of them international speakers and 70 local speakers. In terms of capacity building, just so you know that we have these services available for you. We have sectoral focused trainings on copyright and related rights. We have informational references and resources, guidebooks as we call them. We have the Copyright Program, Plus program, projects and interventions that matter where they matter, and voluntary copyright registration system as copyright notice to the entire world. I'll just go quickly through them. So this is the program that we implemented under the WIPO program on mobile application development last year. And this is a new issuance by the Bureau of Copyright and Related Rights in connection with our accession to the Beijing Treaty. We have a guidebook called On the World Stage, the Filipino Audiovisual Performers Guide to the Beijing Treaty on Copyright and Related Rights. So this is the inside page. We have questions and answers on various provisions of the Beijing Treaty and how it applies to the local situation. Of course, we have the Copyright Plus program, a program that I am very proud of because it is our way of getting in touch with our stakeholders from the copyright sector. It is a flagship project of the Bureau of Copyright and Related Rights, and it's supposed to touch base with the marginalized, unserved, underserved, minority groups, or persons of the creative society. It is proactive, unique, and efficient, and more responsive, certainly because the proposals come from the creatives themselves. So these are some of the programs that we are currently implementing or have implemented under the Copyright Plus program. Okay. We have also Heroes Mural in Baguio, just to promote the art of painting, street art. We also have Protect Writers' Works. We have also the Dance of Disabilities. So it's not just copyright, choreography, but it also involves persons with disability, the PWD community. And we have animation projects. We also have our literary projects where we have compilation of stories and literary writings by mothers during the time of COVID. And lastly, we have the out-of-school youth, the young in the community doing the Indayog Summer Dance Camp. So I presented that because we call for worthy projects that can be supported. At the same time, we are also open to collaborations to other funders that would help us continue this Copyright Plus program. And lastly, I said here that one of our interventions in the area of copyright would be providing them a voluntary copyright registration system. This is copyright notice to the entire world. It should be encouraged, although we know that copyright is protected from the moment of creation. There are, of course, certain advantages to registering your copyright. So we not only made the process easier by going online, but we actually have other uses for it. For example, we have launched recently that the general public may now be able to search for copyright registration online. So all copyright registrations beginning 2021 are now searchable online. Starting first quarter of this year, the data on registration coming from the National Library will also be included in the search database. What are the advantages of this? So if you're a user, you can just go through the list, and if you're interested in asking permission or licensing or having further use of a copyrighted work, then we can certainly refer you and connect you to the copyright owner. I think that's my last slide. Thank you very much, and I'd be open to answer some of your questions later on. Thank you.
Thank you very much, Director Cuyo. Exciting times ahead for the IPO. We see more focus now on the protection and role of users and general public. Less confusion with regard to the CMOs, the netizens reporting piracy and infringing activities, protection of digital citizens, mostly the youth with regard to raising awareness on the advantages of copyright protection, and of course, the Copyright Plus program, reaching out to the marginalized and the underserved sector in the society. Thank you, Director Cuyo. Our next speaker will provide us with a legislative perspective on the development of the creative sector. Let us all welcome Congressman Christopher Toff de Venecia, the representative of the 4th District of Pangasinan and the chairman of the House Special Committee on Creative Industry and Performing Arts. Congressman Toff holds a bachelor's degree in political science at the Ateneo de Manila University and recently finished courses at the Harvard Kennedy School of Government, completing the Public Leadership Program. He is the lead convener of the 60-member Arts and Culture and Creative Industries Block of the 18th Congress, with 11 deputy speakers and 21 committee chairpersons as members, which seeks to introduce and support legislation that protect, promote, and bolster arts, culture, and the Philippine creative industries. With the rigor of both his parliamentary work and his constituency work in the district, he advocates for multi-sectoral collaboration and the expansion of livelihood in the rural countryside through various forms of tourism and agricultural modernization, as well as galvanizing culture and creative industry for economic growth and nation building. We are honored to have you speak to us today, Congressman Toff. You now have the virtual floor.
Thank you so much to Mr. Florian Goting, Executive Director of the European Chamber of Commerce of the Philippines. Thank you. And of course, to your support of the bill. Attorney Emerson Cuyo, Director of the Bureau of Copyright and Related Rights of the IPOPHIL, Attorney Edmund Baranda of the Southeast Asian Intellectual Property Rights SME Help Desk, to our esteemed guests, ladies and gentlemen, masantos yung aram namin, greetings and creativity. My sincerest thanks to the European Chamber of Commerce of the Philippines and the Southeast Asia IPSME Help Desk for inviting me today to talk about the development of the creative sector through legislation. I'm always excited to talk about creative industries from different viewpoints so as to give a better picture or snapshot of the sector. This forum is definitely one of those times, as I will be giving special focus on the importance of intellectual property rights and its relation to the creative industries. But before anything, it is important to establish first where the creative industry sector is as we speak. Estimates from the Intellectual Property Office of the Philippines and the World Intellectual Property Organization showed that the creative industries, otherwise known as copyright-based industries, generated around 661 billion pesos or 7.34% of GDP in 2014. The creative industries also contributed around 4.8 million jobs for the Philippines, or 11.3% of total employment as of 2019. This aggregated as about 4 million, or 2% of the population, being freelance, and around 800,000 employees, creative employees hired in creative firms. It is important to note, though, that these were the numbers before the pandemic. We all know by now that as a result of COVID, all industries had to reshuffle and reboot. On one end, it was the creative industry sector that was severely hit by the pandemic. Film and TV producers had to stop shooting entirely. Musicians couldn't do live shows. Theaters closed. For a while, everyone, to an extent, had to shift digitally. There was a sudden influx of Instagram Live or Facebook Live performances where artists used the digital platform to, at the very least, continue and showcase their craft. Then came the surge of the popular app Kumu, which became a lifeline for creatives in the performing arts. But of course, it's not quite the same as being, in the words of Hamilton, in the room where it happens. Moreover, there were definitely minimal gains in this, as many worked on tips and gratuities, or in the case of Kumu, diamonds, which were convertible to cash. It was only later in the year where we got hold of digital ticketed events. And even if anybody watched recorded live musicals when they were made available on YouTube, our intellectual property laws were not mature enough to get artists their share of remuneration, if at all, that these shows would make, whichever the platform may be. Online piracy was also a major pain point in holding these online shows. You would suddenly see people selling pirated copies of live stream performances all over social media at a fraction of the original cost. And who does this hurt? The creatives, and of course, the firms that provide these creatives with their livelihood. On the more positive end, the pandemic also gave those outside the creative industry sector new avenues to showcase their creativity, skills, and talent. For some, it was a new perspective in life. For others, it became a potential career. All of us would admit that at one point, the pandemic and being stuck indoors for more than a year caused us to tap into our creative side, whether it was rekindling a hobby we had when we were younger, like playing the piano or guitar, or whether it was trying a new hip trend like live streaming or vlogging, or the famous TikTok recipes like dalgona coffee or sushi bake or sourdough bread, or even recently dancing para para G. We all tried to be more creative. For some of us, we use this creativity to be a lifeline for our livelihood. For example, the number of registered online businesses, according to the DTI, went from around 1,700 at the start of 2020 to over 88,000 by the end of the year. A lot of these would be the multiple food businesses that open, further evidenced by the trends in gastronomy as presented to us by the sector in one of our congressional hearings, from cloud kitchens to a surge in food deliveries or homemade crafts that were pandemic born. It was also through this pandemic that we met hundreds of new content creators on digital platforms who now have thousands of followers due to their unique, creative, and relatable way to share their skills or talents online. Even knowledge on complicated matters like the stock exchange, GDP, economics, healthcare, or even inflation has somehow been creatively calibrated to be content on TikTok for mass appreciation. This sudden boom of creativity only further proved what we already know. that the Filipino is truly creative. Filipinos have always been. In fact, the Philippines has the potential to become the top creative economy in ASEAN by 2030. This was the goal set by the Creative Economy Council of the Philippines and the Department of Trade and Industry in 2019. Currently, the Philippines ranks first in ASEAN in the export of creative services, but fifth in the export of creative goods. There's a world's worth of opportunity here. And this has been hindered because no singular government agency or office has taken charge of defining what the creative industries are, let alone of steering its growth and development towards this 2030 initiative. Are creative industries purely culture and arts? Are they mass media? Are they science and technology? Are they copyright based? Are they business? Or are they all of those rolled into one? We do have the potential to be like South Korea or Japan, whose cultures are well known and well referenced around the world. And this is where I, together with the House Special Committee on Creative Industries and Performing Arts, decided to make our move. Over the past 2 years, I, along with other members of the Arts, Culture, and Creative Industries Bloc of the 18th Congress, or ACHIB, have been fortunate enough to meet with various stakeholders within the creative industries. I was surprised at just how many sectors were out there besides theater and the performing arts, which was really my background. I was familiar with film, radio, television, print and publishing, music, fashion, furniture, and visual arts. My work in the media allowed me to interact with stakeholders from these sectors as I featured them in newspaper and magazine articles before. But I didn't realize that, animators and software and game developers, architects, interior designers, urban planners, gastronomes, among many others, also fell within their ranks. This list truly is very diverse and expansive. Some sectors are more organized and self aware than others. Some dabble in traditional media, others are more digitally inclined. As Attorney Emerson shared earlier, some sectors have organized CMOs to act in behalf of their constituents and members, others do not. And outside of the copyright lens, some sectors have prominent business support organizations who are at the forefront of the creative economy movement, and some are very much disorganized, and there is still an opportunity to be able to organize everyone so that everybody has a seat in the table, at least in that sector. Each sector has its own peculiarities, as we've realized in our hearings, and it requires a very fine-tuned approach when it comes to policy. What I have come to realize, though, is that the thing that binds all of these sectors together is the spirit of originality, innovation, and God-given talent and creativity that governs our creative workforce in everything that they do. And of course, the key differentiator between traditional industries that may use creativity to boost their productivity and industries that are considered creative in themselves is intellectual property and having a trajectory towards developing an intellectual property ecology or IP ecology. So I think that's something that should be of note, because you can argue that creativity can be used in absolutely any industry. And yes, certainly that is true. Creativity is a function of innovation. And when industries learn how to use creativity and creative industries and their services output, then they're really able to improve their overall productivity. But then there are industries that are considered within the UNCTAD framework as creative industries in themselves. And really the differentiator, I repeat, is intellectual property and proclivity towards an IP ecology. But given those sectors and being well aware that there were government agencies that were mandated to cater to them, where essentially was the gap? And so we thought that perhaps what was missing is not really the effort nor the talent, perhaps not even the resources, but the understanding and the subsequent governance framework, the policies, the roadmaps, which were initially mentioned by Attorney Emerson earlier, and most importantly, collaboration between and among agencies as well as among the various sectors. Because even within the creative economy ecosystem, um, some sectors are not aware that other sectors actually fall among their ranks. The end result is our major piece of legislation, which is the Philippine Creative Industries Development Act. We are happy to report that it has been passed in the lower house and is pending third reading before the Senate, meaning we are almost there. The bill, when passed, will constitute the major framework for developing the creative industry sector. This will allow the representatives of each of the 9 developmental domains, as informed by the UNCTAD framework, to partner with the different government agencies so that there will be a plan that will pave the way for this sector to flourish. The council, or the Creative Industry Development Council, which will be created as a consequence of this measure, will serve as a coordinating body for all government agencies with some form of mandate to develop the identified creative industries via clustering. This also helps our government agencies form their efforts in lieu of a much bigger plan. Part of the council, part of the would-be council would be IPOPHIL. And at this juncture, I would like to take this opportunity to thank them for their input and insight as we were crafting and deliberating on the measure. The IPOPHIL is just one of many agencies who serve as beacons for developing a future for the sector. They will pave the way towards a strong IP ecology and for the creative industries to become truly world-class. The Creative Industries Act will seek to ensure that the government always takes a long-term approach on our investment in creatives. This means tax incentives, grants, and loans will be made available to ambitious creative projects. This act will also include a development fund, a portion of which will be allocated for worker protection. And we insist that as we grow creative firms and businesses, that workers don't get left behind to ensure inclusivity and, more importantly, sustainability. Intellectual property protection is also a component of the bill. Under the measure, the council will be able to assist our creatives from R&D to marketing and promotion, from ideation to protection of their IPR. The creative development plan will point out the benchmarks that the state and in partnership with the private sector would want to achieve within a certain year. We mandate the creation of short, medium, and long-term plans for each industry. Short in the 3-year period, medium in the 6, and long-term in the 10. The council will also be able to assist in capacity building by establishing programs that would be able to cater to our creatives, at the very least help them understand their intellectual property rights and how these can be protected. And lastly, this will also allow creative MSMEs access to Go Negosyo centers in each local government unit and the services that these would provide. There are other programs that we institutionalize in the bill. One is the Creative Startup Fund, which I think is very important because to formalize into the economy, some resources are needed to register your business, to apply for those receipts, and starting creatives and freelancers might not have that kind of capital. So we do create a startup fund to assist. We're targeting 40 to 50,000 freelancers in the initial rollout. And there are actually many other programs that we will be creating. You can just refer to the bill, it's online. The Creative Industries Act is about building a solid foundation for the creative industries, providing them the adequate and appropriate tools and opportunities to grow, and giving them the forum, most especially for coordination, cooperation, and collaboration. But this is just really the starting point. Together with the Creative Industries Bill, there are other complementary measures like the Freelance Workers Protections Bill, which is meant to provide for the rights as well as legal recourse for freelancers. We also filed the Eddie Garcia Bill, which is meant to provide occupational and safety standards in the audiovisual sector. Additionally, the Eddie Garcia Bill also ensures the protection of the performer's inalienable right to remuneration over their intellectual property, even during subsequent broadcasts of their work. This is because we recognize that intellectual property remuneration is one of two sustainability mechanisms for our artists, the other being professional fees. So I'll repeat that creatives really only earn two ways. One is through professional fees, and the other is through intellectual property remuneration. So if you take one out already, you have their sustainability lifeline. Both of these are still pending before the Senate, and we really hope that these measures are passed to complement our plans for the sector. But definitely the next question is, where do we go from here? What else can we do with our legislation that can help this sector? Particularly, what can we do in the field of intellectual property to protect our creatives? As Attorney Emmer mentioned earlier, our IP code turns 25 this year. And due to rapid modernization of society, there are still major gaps in both the law as well as its enforcement, particularly when it comes to our creative industries. We launched two congressional hearings into various forms of IP infringement that we envision would lead to the creation of additional protective measures and mechanisms for our stakeholders in the audiovisual and design industries. One of these was launched in early 2020 in the wake of reports of counterfeiting of weaving patterns from the Cordilleras, which were being brought into our own country and sold at our local textile markets at the expense of our indigenous cultural communities. What we discovered was that our country's indigenous textiles and weave patterns have been receiving their well-deserved recognition, not only in the domestic market, but also in the global fashion scene. One must also note that these indigenous output are sold at a premium, these weaves being artisanal in nature, and that you can't make them in huge bulks, and also immediately on demand. But with this growing popularity also came, the pirates. Intellectual property violators were quick to realize that our indigenous weaves are in short supply and not sufficiently protected under existing laws. In many of our meetings, the consensus was really that these unique output would need a sui generis protection to be truly and effectively preserved and protected. One major factor to consider is definitely the access to intellectual property protection. In the specific case of our IPs and ICCs and their creative output, which is actually intergenerational and handed down from one to another, there has been no clear form of registration that is accessible to our indigenous peoples and their communities. There's also an issue of the understanding of intellectual property rights, especially in the more far-flung indigenous communities. And even among creative firms and MSMEs, that even with the best of intentions, even if they would want to celebrate them, sometimes they forget that, consent would need to be obtained through the NCIP or the National Commission on Indigenous Peoples, and that some weaves are actually sacred in nature and should not be co-opted um, for commercial purposes. Meaning to say, certain weaves can't be used for fashion designs, and there seems to be a lack on both sides of the spectrum, both on the firms and businesses, as well as the IPs and ICCs themselves. This is the gap that we in the legislative sector need to revisit in the next Congress. Certainly, there have been proposals for some kind of database, a one-stop shop to be able to identify the communities and the type of output that they create, which can be a reference point for creative firms and MSMEs, and then maybe there can be a proper collaboration moving forward, because you also do need the creative firms and the MSMEs to help be able to sustain these communities. That's just one. Another possible avenues to consider the proposal of Deputy Speaker Lauren Legarda to have a separate system altogether for the registration and archiving of our traditional cultural heritage, and giving them their respective intellectual property protection, separating it from the current regime of things to be protected by our current intellectual property code. Definitely, this is a proposition worth refiling in the next Congress. But what is paramount is the appropriate protection of our creatives, especially those engaged in traditional cultural expressions. One of 9 developmental domains in the bill, again, as guided by the ONCTAD framework. Another proposed measure is a package of amendments to the IP code that directly affects the creative sector, particularly addressing the lack of protection over sound marks and non-physical marks. Attorney Emmer kind of mentioned some of these reforms, much needed reforms earlier. A couple of examples of most recognizable sound marks in the Philippines include, for example, the station ID of ABS-CBN or the Nestle ice cream cart jingle. And I'm sure even as I'm mentioning it, you're humming these in your head. These sounds, no matter how much they exude a trademark, are unfortunately unprotected under our current intellectual property laws. This is in fact one of our commitments in the Regional Comprehensive Economic Partnership, or RCEP, although such has yet to be ratified by the Senate and be expressly supported by Malacanang. And with the remaining days of Congress after the elections, there might not be enough time to be able to really ratify this treaty, and so we miss out really on a lot of opportunities, and it will need to be revisited in the next Congress. But by amending our current code to remove the restriction that marks should be visible, the creativity of the Filipinos will then be incentivized and protected. It is a known fact, after all, Filipinos are very music-oriented, and this will also allow Filipino brands and products to be more competitive in their markets, as registering marks would help calibrate their respective marketing strategies, and this time with a sense of protection over their respective brands. To bring it back to our indigenous peoples, many of our tangible cultural heritage and traditional cultural expressions would benefit from this move as well, and could get the proper protection from cultural appropriation or straight out piracy. Note that a good amount of our cultural heritage is intangible, which includes oral traditions like the hud-hud chants of the Ifugaos, or the zarzuelas of the Tagalogs, or even the weaving methods of the Cordilleras. The weaves themselves are tangible, but just the process of which it emanates from their dreams. I mean, that's really something that's on the more esoteric side. But all things being said, pursuing this amendment will truly be beneficial for our creatives. We also need to amend the code to strengthen IPOPHIL's role in enforcement. The judicial route, while ideal, is too slow and does not really address the reality that piracy and proliferation of copyrighted work in the web can happen in a matter of minutes. There must be a way to nip it in the bud before the damage is ultimately done. And the IPOFIL should be given more powers to be able to expeditiously address this. We intend to seriously look into this matter in the next Congress, and I intend to participate more rigorously in the debates on the need to be expeditious about nipping piracy and its spread in the bud vis-a-vis the concept of due process, which should be afforded to all citizens, but not at the behest of our creative industry stakeholders, and not to their detriment. We are also looking to revisit the current Republic Act 9105, or the Art Forgery Act, to modernize the same. Currently, the law does not cover digital art, nor does it include the IPOFIL in its framework. Given that art forgery is an intellectual property issue, we find it necessary to include IPOFIL in its art authentication panel, and maybe to remove national artist and the duties of having to authenticate art, because that's not their role. And to expand the coverage of the law to keep up with consistent evolution of art and its different media. And I suppose in relation to this, we also have to find a way to be able to better implement the provision in the IP code with regards to the resale of visual art, because if I'm not mistaken, the artist is entitled to about 5% remuneration of the original value of the artwork. But then if his or her artwork is resold, how would the artist know? Especially if the sale is done in private. Maybe it's about establishing some kind of mechanism by which galleries can register, but private collectors, it would be a much harder reform to undertake. And this is something that the internet and digital disruption has been able to address. And it was mentioned partially mentioned by Attorney Emmer earlier, the concept of NFTs, or non-fungible tokens. Like as the digital artwork moves from one owner to another, there's automatic remuneration to the artist. And so it's one of those things where do our archaic laws able to keep up with digital disruption? And lastly, we also need to make the message clear that it's not okay to steal. It's not okay to steal traditional property. It's not okay to steal intellectual property. We do not and should not have any entitlement over copyrighted, patented, or trademark items that do not belong to us. Piracy is a crime, and this is something that should be taught as early as elementary school. Thus, there is this need to hammer the point to the youth, whether it is through the incorporation of this very matter in the K-12 curricula or through stronger information campaigns. What matters is that we teach people the message that it is never okay to steal. Some findings from our stakeholders is that there seems to be this sense of entitlement among Filipinos that it's okay to steal intellectual property. Like it's okay to download pirated content. It seems to be part of the fabric and DNA and the lifestyle and culture of the Filipino, whereas it is certainly frowned upon in other countries. And so this is something that really needs to be addressed early on. And these are just some of the different paths we can go for the future of our creatives and the protection of their rights, particularly their intellectual property rights. And the groundwork is already here. The foundation, which is the Creative Industries Act, is almost set. We have what it takes to bring the creative industries to the next level. We have gained serious momentum in pushing for the recognition of the creative industries. And our next step is really to ensure that this momentum becomes stronger in the next few years. I really, truly congratulate IPOFIL on their many initiatives to educate and be of service to the creative sector. And I urge the agency to continue doing the same even in the years to come. This means that with the recognition and the opportunities our creatives will get the much needed protection of their work. This will motivate our creatives to be more productive without fear of infringement. This will empower our creatives to achieve fulfillment in their own crafts. And this will make our future truly, truly creative. I'm sorry I won't be able to stay for the open forum. Obviously, it's campaign season. I'm running for re-election. I have three sorties I have to catch up to. But thank you so much for this opportunity. Salamat at sige namin. And masantos ya ngaram at sige namin. Thank you so much.
Thank you very much, Congressman Toff. As a creative yourself, we can really see that your heart and mind are 1000% aligned with the Filipino creatives. Thank you, Congressman Toff. Okay, so we move on with our third and final speaker, Attorney Edmund Jason Baranda. He is our external expert at the Southeast Asia IP SME Help Desk since 2013. Attorney EJ is the managing partner of Baranda and Associates, a member of the global IP firm Rouse. He is a recognized expert in intellectual property and is involved in IP prosecution, IP commercialization, and IP licensing. He also litigates intellectual property actions and conducts enforcement actions. He has a degree in molecular biology and biotechnology from the University of the Philippines in Diliman and obtained his law degree from the same university. He was admitted to the Philippine Bar in 2001, and in 2007 he obtained his Master's of Law from the University of Michigan Law School with intellectual property as his area of concentration. He is also admitted to the New York Bar. Attorney EJ has an international experience as a legal practitioner, having served as a foreign legal advisor in an established regional law firm based in Singapore. He currently teaches IP law at the De La Salle University College of Law and previously taught IP law courses at the Ateneo Law School and at the UP College of Law. Thank you for joining us today. Attorney EJ, a chamber favorite, you may now have a virtual floor.
Thank you very much, Vina. I think ACCP has a slide for you first before I speak. But anyway, while they set that up, I'd like to thank the ACCP and also the Southeast Asia IPSM Help Desk for inviting me to speak. I'd also like to say good afternoon to Director Emerson Cuyo and Congressman Toff Demencio. Unfortunately, cannot stay. Should I proceed to my lecture, or Nora, do we first show the slide on?
Yes, hello.
Okay.
Yeah, hi. I would like to give a quick introduction to the project, and then you can go ahead with the presentation. So if we can, if Kat can just show the services slide. I think it's right after Edmund Bias. The game, sorry. Okay. So we wanted to play a little bit with the both on-site and online participants to ask 2 questions from the participants related to the presentation. So the first question would be, IP commercialization is only about selling your IP to third parties, true or false? So we invite you all who are attending online to tick the suitable option that you consider. And then later we will share the result. And we appreciate if maybe in the room also with a quick hand raise. I don't know if you can coordinate that. I let you guys see. And the second question is, once my IP is registered, I will not need to carry on any other action, and my IP will be protected automatically against infringement. This is an efficient IP protection strategy. True or false? So we give you 30 seconds and then we can move to the next slide.
And hopefully after my lecture, you'll have some reflections on your answers, and maybe we can discuss the results as well.
Yes. We are curious to see if you change your mind throughout that presentation. So if Kat, you can share the result just for us to see the statistics. Yeah, so for the first question, 6% said true. We have a majority of false. And
Okay.
for the second question is closer. So I think there you
Yeah.
need to convince some of the attendees.
Okay. The results of the second question, that's pretty interesting. So okay, hopefully after my presentation, we'll have some clarity or we'll have some more insights. All right, so if you can move on to the next slide. Okay, so
Thank you.
Thank you, Nora. We've heard from Director Cuyo on the present landscape, IP landscape here in the Philippines, and we've heard from Congressman Tof de Venecia about the future landscape. He has identified some gaps in our IP system that need to be closed, and hopefully through legislation we'll be able to close those gaps. And I myself, I'm really looking forward for the Philippine Creative Industries Development Act to be passed into law, and hopefully within this Congress it will pass into law, because we really need that law to address some of the gaps. So okay, so I was tasked to talk about IP in the creative sector. 15 minutes obviously will not be enough to talk about that, but I think what we can do for the next 15 minutes is I'll give you tips on, given the current landscape, how do you, number one, identify your IP? If you are part of the creative industry, how do you identify the IP that you create? How do you protect that IP that you create? And then, as equally important, how do you use or how do you commercialize that IP that you create? I understand that some of the participants in today's webinar are from the design industry. I saw also from the list that there's one from an architectural firm, and also there's one from the advertiser or marketing industry. So what we all have in common is that you create IP in those industries. And what you can see from the slide is what we call the creative process. And I'd like to believe that anyone who is part of the creative industry will undergo this creative process. So any creative process starts with the generation of ideas. For example, if you're from a design industry, a client comes to you commissioning you to let's say produce a package for their product. So that's the task, and then as a designer, then you come up with some ideas on how the packaging should look, given of course the client's product, the target market, what sort of message do they want to convey. Or if you're in the advertising or marketing industry, a client comes to you and say, okay, we have this product, we want to produce a TV ad for this, or an online video that will be shown on social media. So again, that's your assignment. So how do you now come up with a TV ad? What sort of how do you want that to be executed? So again, the creative process starts with the idea. So you've come up with an idea to either because you have a client that asks you to create a product, or you yourself will be creating that product, which and again, to create that product, you start from the idea. So generative ideas, and then the next step I like to believe is product development or know-how. So from that idea, you now test the idea. Does it meet the objective? You explore other ideas. You test these ideas. If these ideas can be transformed into something that will be that can be protected by intellectual property, or can be integrated in the products or services that you want to that either you want to put out in the market, or that you want to sell to your customers, or because someone commissioned you to do that. So after the product development and know-how, maybe not applicable to all creative processes, but you come up with the logo or branding for your product or service. So how do you want your product or your service to be known by your market? And logo and branding is a very important part of that. So now that you're ready with your product, you have a logo. Now you want to market that. And in the slide you will see digital, because as everyone knows, after the pandemic, digital advertising has almost been the norm nowadays. I mean, of course there's TV, there's also newsprint, but everyone's on social media. So if you want to reach your target market, you should advertise in the digital platform. So marketing, how do you want to market your product now that you have a logo, now that your idea has become an actual product or an actual service? How do you market that to your target market? And then this may not necessarily be that comes after marketing, but commercialization. Even after logo branding, it will also go straight to commercialization before marketing. So in commercialization, that's when your idea, which has now become a product or a service, now you want to sell or distribute that to the public. Now, in all these steps in the creative process, if there's one thing that I want you to remember in this very short presentation is that you create IP, you create intellectual property in each step of this process, or if you don't create IP, you use IP. So it's very important for you for anyone in the creative industry to recognize that the creation or the use of the IP, because if you're not aware that you are creating IP, then you will not be bothered to protect your IP. And if you don't protect your IP, you won't be able to license or commercialize your IP. Or if you're not aware that you are using IP, for example, for marketing, going back to my example of a TV ad, you decided to use certain music or certain photographs or certain video footage in your TV ad, and you are not aware, or at least you didn't perform due diligence. You were not aware that the photo, the video, or the music you're using for their TV ad is covered by copyright protection, and you didn't get the necessary license. So that will obviously get you into trouble later on. An IP infringement case can be filed against you. So this recognition that in the creative process there's IP created and IP's use is something that everyone in the creative industry must remember, because if you can see from my slide, at the end of the creative process, IP should be, the IP that you create through this creative process should be protected. Obviously, it should be deployed, because what's the sense of creating all these wonderful products, wonderful works of art, if you're not able to deploy that and distribute that to the public? And then something that maybe not all of you are aware, you need to manage as well the IP that's embedded in the product or service that you put out in the market. If we can move on to the next slide, please. All right, so I just want at this point I want to talk about the interplay between innovation, IP, and commercialization. For those of you in the creative industry, maybe some of you are not too aware about intellectual property and how to create or how to protect that. But I'm pretty sure that innovation is something that you are very much aware, and something that you always aspire for, because without innovation, you can't compete. Without innovation, you lose out on the competition. So there is a relationship between innovation, IP, and then commercialization. So in innovating, as shown in the slide, it's a process that translates your knowledge or your ideas into something that will contribute to economic growth, and maybe in a philosophical point of view, also it contributes to social well-being. So innovation can be scientific, it also can be technological. So it's about maybe inventive, some inventions, some innovations that are technical in nature. But the innovation can also within your organization, something that you introduce to your organization that will make the running of your business more efficient. It could be a financial innovation. And obviously, through design and creative commercial activities, you'll have innovation. Now, when you innovate, sometimes or not all the time, you will create IP or you will create intellectual property, because the IP will capture, and that will protect also your innovation and creativity. And once you have identified, you have captured, you have protected your IP, then, as I've said earlier, you can commercialize your intellectual property. And since IP is essential in anyone who's in the creative industry, you will need to know how to protect that, because corporate innovation and commercialization is a huge part of every sector of every economy. Now, if you skip the IP step, you will inevitably reduce the company value and company revenues. Especially now, it's a digital age, and this was highlighted when because of the pandemic. If you don't have anything innovative that you can offer, then your company value and your revenues will suffer. Okay. Okay, next slide, please. So IP is an intangible, and again, most businesses today are driven by intangibles, but not all intangibles are IP, and of course IP is always an intangible, but these intangible assets that you have, it's important to recognize what they are, and it's also important to identify the IPable IP asset. So the IPable intangible asset that you have. So if I can turn your attention to the lower leftmost part of the slide, you can look at intangibles as this pie. So you have intellectual capital, and then you have intellectual assets, and then you have IP at the core. IP is, and I will discuss this later on, these are your non-physical assets that you can legally protect. So we have an IP system to protect your intellectual property. And that would include, you've heard this before, your patents, your trademarks, your designs, your copyrights, and your trade secrets. What's the great thing about this kind of intangible, which are all part of most of everyone's businesses, is that you since you're legally protected, that means that you can stop other people, your competitors from copying your products or your services. Now, beyond IP, we have what we call intellectual assets. So they may not necessarily be IPable. When I say IPable, registrable as an IP or recognized as an intellectual property, but it's still part of your assets, which you can legally own. You can also use. You can trade and or even license. Okay, so that would include know-how that not elevate to copyright protection. That would include data, again, because data per se isn't copyrightable. Even the contracts that you have between your company and let's say your licensee or your licensor, that's your identifiable assets. The IP that you license from other entities. Your relationships as well, company relationships, it's something that's an intellectual assets, because that's your reputation. It's something that you can bank on in running your business. Any awards, again, again it goes back to your reputation as a company. Now, beyond intellectual assets, we have what we call intellectual capital. Now, you don't own these assets, but you benefit from using that. So that would be the skills of your workforce. It could be the experience, your experience as a business owner, or the experience of your workforce, and also, know-how of your team should be part of intellectual capital. Not intellectual assets, because you don't own this know-how, because it's your team's know-how. Okay, so next slide, please. So now that you have an idea of the intangibles that, like I said, are owned by many businesses, especially those in the creative economy. So now you've identified, your IP assets, and hopefully you have an idea what your IP assets are now. And then maybe the next question you need to ask is, why do you need to protect this intellectual property? So let's dive deeper into that. If your IP is protected, so meaning your patents you have patents over your inventions, your trademarks are registered. Well, your literary or artistic works are copyrighted. Well, as Director Kuya said, you don't really need to register your IP, but for us lawyers, we encourage you to register your copyright just for enforcement purposes. So once you have an IP that's protected, then that's a tradable asset. You can it's something that will help your company to perform deals. Obviously, if you want to license that, if you want to put your product out there in the market, if you want an investor to to invest in your company, I don't think they will be interested in your company if you did not do anything to protect the IP that you generated. Okay, so if you can show to your prospective investor that you have an IP portfolio that's protected, then that will facilitate the deal. And since IP is a legal right, then you can enforce that. You can stop other company from copying and from using your products and services without your authority, and that's obviously a market position and timing advantage. And in line with that, you also protect your company's own use. So that means that you are free to use the IP that you created without expecting any interferences from other businesses. Because one of the worst things that can happen to companies that you invest so much in developing a product or a service. For example, a TV ad. You spent millions to produce a TV ad only to be sued later on for copyright or for copyright infringement or IP infringement. So that will definitely interfere with your business. That can have a huge dent in your revenue. And studies have shown that if you're an IP-rich business, it will help you grow faster. So there are studies that have shown that there's positive association between companies that own IP and their economic performance, and especially for SMEs. Most SMEs in the beginning, their main assets are really the intellectual property that they create. Okay, and if you don't have IP, that's a legal risk. Because I can tie this back to IP being a tradable asset. There's higher financial costs because if you don't have IP, you need to always license IP. You always need to ask the permission of a copyright of an IP owner to use that IP in the products and services that you put out there. So that will obviously increase your cost. That would result in delays in delivering what you're supposed to deliver, and there's also possible disputes. And my last point here is why you protect IPs, because if you have products where IP is embedded, they will have higher value than other commodity products because that makes your product stand out. Again, studies have shown that SMEs that own IP, they have a 60% higher chance of 60% higher revenue per employee than SMEs that do not own IPR. So it's important that you aim to produce IP and not just a passive user of IP or a licensee of IP. Right. Next slide, please. Again, 15 minutes is not enough. We have a whole 2-hour or 3-hour course to talk about IP and how to protect IP. But let me just give you a brief overview. And I'll relate this to the creative industry sector. So IP, there's your brand, your logo. So once you have your product, you have your service, like you're a graphic agency, you're a design agency, you're an architectural agency. It's better to have to brand, to use a brand so that you're a distinctive brand that will help you that will help your company be distinguished from the other companies out there. So trademarks, that will be your brand, your slogans, your trademarks, and here are some examples. And how do you protect trademarks? You need to register that. It's not enough that you create your logo and that's it, and then you put it on your products or put it on your website. No, you're not protected until you register your trademark. Okay, I'll skip digital IP assets. I'll discuss that last. Then your designs. Same. If you're in a design industry, you help develop packaging for your companies, for your clients, or even for your own products. Or you're a furniture company. Of course, obviously, you make your own designs for your furniture. So that's the aesthetics. You're protecting the product shape and configuration, and you use those designs in furniture, packaging, and fashion design. Again, it's not enough that you end with designing it and then giving it to your client or embedding it in a product and then putting it out in the market. It's not enough to protect your designs. You need to register your designs as well. Okay. So patents, maybe not so much applicable to those in the creative industry. These are technical solutions to your problem. An example, maybe you're in the furniture industry, you design ergonomic chairs, and then you develop a technology for ergonomic chairs to make it more comfortable. So that's a technical solution. Again, you need to register that to get protection. And then copyright, which I guess is what a lot of you here in the webinar are creating. Copyrightable literary and artistic work. So these are your software, your written works, your graphics, your music. Our design can be both copyrighted and also protected as a design, as an industrial design. Now, as a director, again, you don't need to do anything for copyright for you to have rights over your copyrightable works, because copyright vests from the moment of creation. But you do need to manage your copyright. And how do you manage that? You need, first, of course, you need to make a list of all your copyrightable works. You need to put a notice to the public every time you put your copyrightable work out there by including the copyright sign. Copyright, you've probably seen this in a lot of, maybe in movies, towards the credit you see copyright, and even in the beginning, and when the first slide of ECCP said this whole session is copyrighted. You're not supposed to copy it. You're not supposed to distribute that. Okay, so so those are the four major IPs, but I also want to mention digital IP assets. They're not strictly speaking a separate IP, but because of its prevalence, because of significance in today's digital economy, just wanted to highlight that. You also have digital IP assets, which is your domain name, your social media handles, your Twitter, your Facebook handles. Those are also digital IP assets, which may or may not be registrable as a trademark. But those are definitely assets that you need to protect. So your social media, for social media, and for Facebook, for TikTok, for Twitter, the handles that you use, those are the digital assets that need to be managed. Okay, next 2 or 3 slides, I think, then I'm done. So all this IP. How do you protect them? 3 basic steps. Again, not enough time for me to discuss, but this is just an overview, and hope you get something from this. So if you create IP, you either register that or you capture that so that you can manage that. So again, I've already talked about trademarks and patents and designs needing to be registered, and copyrightable works, you need to manage that. So you capture that. Make sure that you may have a database of copyrightable works. Okay. So and how do you manage your IP? Make sure that you are aware of the renewals, because, for example, trademarks, when you register trademarks, it's just good for 10 years. And in the Philippines, it's a requirement for you to prove use of the mark. In other countries, they don't have that, but here we're very strict. Provide proof of use within 3 years from the filing date, and then when you renew your registration, that means on the 10th year you will have to prove that you use it again, and then on the 5th year of registration you have to prove. So again, it's constant proving to the IPO fail that you're actually using the mark. You have to have a database for unregistered rights. So what are those unregistered rights? The IP rights that you don't need to register, but still these are your IP assets that you can commercialize later on. So copyrights, even trade secrets, assignments of third-party created, let's say through a design agency. You need to make a database for that. And then once you have this IP is in use, it should always be aligned to a product or service. So you don't create IP just because you want to create IP. At the end of the day, we want to commercialize. We want a profit from the IP that you create. So make sure that an IP portfolio is created. You match that with other intangibles. So contracts, awards, data, and then you regularly audit that. So the whole business or your entire business unit is protected by an IP package. And finally, the third step here is that products and services are created and sold with IP inside or behind them. So when you put out your products and services out there in the market, make sure that the IP is embedded there, and then when you do deals with third parties, make sure that you make them aware that you are claiming IP on the products and services that they deal in. And it's essential, of course, for you to have the right contracts with the right provisions to embody all those. In large companies, you have an IP team that does that. They will hire law firms like us to manage that. But in SMEs, that's the challenge, really. And it is why we have these seminars, and this is why, as Director Cuyo has mentioned, the IPOPhil has a lot of programs for that. If you want to learn more about that, you can go into IPOPhil. You can probably attend some of their seminars, or just go through the the references, all the sources that the IPOphil have, they've already curated that for people in the creative industry. So I think at the very least, you know where to go as the first step. Okay, my last slide are key takeaway and tips. So again, I want to emphasize in the creative process, you either create IP or you use IP in every step in the creative process. And make sure that you know about IP ownership. Remember the general rule that if the IP will be owned by the employer, if the IP that's created by the employee is part of that employee's regular duties. If it's a commissioned work, you ask someone to create IP for you, the general rule is the creator will have the copyright to that. The second takeaway is that know how to recognize the IP that you create and use in the creative process, and then your limitations on the use of that said IP. If you're gonna embed another work, a literary artistic work in your product, or you will use it in the service that you provide, make sure that you obtain permission of the copyright owner or the IP owner if that work is not part of public domain. And then again, limitations on your use. Be conscious of up to what extent you can use the IP that you embed in your business or in your products and service. Make sure that your use of the work is covered by the license, and it's all the use that you intend to do, all the use of the IP that you need for your business, that should be covered by the provisions of your license agreement. And my last key takeaway would be always protect your IP that you create so you can license that. So register your designs and mark with the IPOphil. In your works, always include the copyright notice. Again, the C with the C encircled with the circle. And then if it's not IPable, that means that you cannot register it's a copyright. You execute what we call non-disclosure agreements, so that you bind the party to your contract to recognize that you own this asset, IPable, non-IPable asset, and therefore if they violate the contract, then you can ask for damages. Okay, that's it for my presentation, and in closing now, having heard what my presentation, are you changing your answer for number 1 and number 2?
Yes, thank you, Edmund. Can we quickly launch the last 2 poll questions so we can see if there is any change in participants' opinion? Just we give 30 seconds and then we move to the Q&A. Thank you very much. I think we can see the results, so speakers have time for the Q&A. Can we share the result? Oh. Interesting.
Okay.
Okay.
As an IP lawyer, though, maybe we can start the Q&A rolling. For number 2, I would say that it's false. You need to carry more action because once your IP is registered, remember what I said earlier, you need to manage your IP. So it's not an efficient IP protection strategy if you stop with the registering your IP. You need to have a system of managing your IP. Managing would include making sure that you renew it, making sure that you have a way to track the deadlines for renewal. You have a way of maybe being aware of the sort of license fees that you can get for your IP, stuff like that. So, but yeah, interesting results. We'd be happy to answer more questions.
Thank you, EJ. EJ, as usual, you amazingly condensed a semester worth of intellectual property study. But that was really very clear and also very insightful. With EJ, I forgot to mention is Miss Nora Bihari from our ever loyal partner, the Southeast Asia IP SME Help Desk. Thank you, Nora. Some of the services of the help desk are also posted via chat. Benoit graciously posted a link there. Please feel free to check out the link that we share. Okay, we have so many questions for EJ and Attorney Kuyo. But before that, I would like to gently remind our virtual audience to please use the Zoom Q&A function to submit your questions to our panelists. The Q&A button is located at the bottom portion of the Zoom application. If your question is directed to a particular member of the panel, kindly indicate that as well. And for our physical audience here in the room, please raise your hands if you have questions, and we will try to cover as many questions as possible within the allotted time. We have so many questions coming in for our two speakers. Um, okay, okay. Let me start with okay, this question. As consumers of various data, what are the simple steps we can take to avoid infringing someone's intellectual property rights? So here we have someone who is a user probably of intellectual property right. We've been discussing for the past hour how to protect owners of intellectual property rights. But this time, how about the audience? How about the users who would like to respect IP, but at the same time enjoy also the IP? Perhaps we can start with Director Kuya first.
Uh, as users of various data, and simple step I think is to double check, especially if you wanted to share it further with others, for example, on your social media, because sharing is actually one of the rights. Communicating it further is one of the copyright afforded to the creator. So only the copyright owner has that option to decide who to share it further with. So not everything that you find on the internet actually, just because it's freely available on the internet, means that you can also freely share it. So just make sure that things you're using or downloading from the internet are covered or not covered by copyright protection.
Thank you, Director Kuya. EJ, any comment?
Yeah, if I can add to that, just be conscious that there's a copyright notice. As I said in my presentation, if there's a C with a circle, I think that's a sign to you to be careful about using that whatever data or whatever work that you're trying to use. Best to clear with the copyright owner if you want to use that piece of work. But at the same time, do remember that we have a very strong fair use provision here in the Philippines. And there are we will need another session on fair use, but basically it's fair use if you're not profiting from it. Most copyright owners are okay with you using their IP, using the copyright as long as you're not profiting from it. Once you're profiting from it, then I think that's when the copyright owner will step in and say, hey, you need the permission. You need to get a license from me before, since you're already profiting from my work. Yeah.
Yeah, that's right. I remembered Congressman Toff discussed a while ago the culture of entitlement, and
yes,
that is that is a culture that we would like to stop, especially if we want to protect our IP owners. Okay, we have a question here for Director Kuyo. Have many parties availed of the IPO MC 2020-22 as a means of settling disputes regarding the terms of a license involving the author's right to public performance or other communication of his work?
Yeah, to quickly answer that, there has been no takers of that particular one. So the challenge really for us is to explore further that particular limited jurisdiction given to the Bureau of Copyright and Related Rights. I think this would be very similar to the function of the UK Royalty Board, which is an older establishment, an institution established older than the Bureau of Copyrights, and based on their experience, they also do not have a lot of cases falling or submitted before them. So we'd like to explore that further. I would like to think it's a challenge. In the past, there has been 3 instances that that particular provision of law was utilized, but after that, I think there has been no takers of that particular limited jurisdiction.
Thank you, Director Kuyo. Another attendee is interested with NFT. As we move forward, what are the programs for NFT artists, or are we equipped on supporting this platform? Director Kuyo said that it was still under research at the moment.
Yeah. I think at this point we actually tackled non-fungible tokens as a topic during the Philippine International Copyright Summit in November of last year, and I think there is really a need to study further because the first thing we ask is, what do you really get when you buy a non-fungible token? So there's a need to further look into it because, as you would note, a transfer of the NFT is not actually a transfer of the copyright. So I don't even think at this point that it's within the scope of copyright itself, in the same way that cryptocurrencies are outside the scope of copyright.
Vina, if I may add to that, to what Director Kuyo said, because some NFTs are not copyrightable, definitely. So as Director Kuyo said, it's a puzzle, even to me, that what people would pay millions of dollars, for example, for the first tweet. That I don't think that's copyrightable because it's not original. So in determining whether your NFT is IPable or not, we go back to our basic laws on intellectual property on whether it's copyrightable or not. If it's copyrightable, if it's original, then it's copyrightable. But there are some NFTs that are at the same time copyrightable. For example, I know this Indonesian guy who took photos of himself every year, and I think he sold it for millions of dollars. So someone was I don't know, not say stupid enough, but someone was, I don't know, maybe he really just loved the pictures, but he paid millions of dollars because the Indonesian photographer selling it as an NFT. But again, if you I want everyone to remember that if you buy that NFT token for millions of dollars without the transfer of copyright, the photographer, that Indonesian guy, will still retain copyright over those photographs. So that means that you don't have exclusive ownership of those photos. He can always display that. He can make a book out of that. He can put it on his social media page, and you can't do anything about that because that's no longer the NFT. Because what you're holding as an NFT is the very first photos uploaded on social media. So, but again, yeah, it would be interesting to have maybe a sui generis legislation on NFTs, considering that it's the in thing nowadays. Thank you.
Thanks, EJ. Okay, speaking of millions of dollars, we have the Personal Property and Securities Act, which is hoped to help IP owners raise funds using the IPs as collateral. Unfortunately, we have not seen many financial institutions willing to lend on the back of IPs. One of the challenges is that the banks are not used to valuing IPs. Is there something that we can do to encourage more financial institutions to be more open to accepting IPs as collateral? EJ, perhaps you want to take a crack at this question.
Yes,
first?
please. We actually have a project on that. This time with the UK government, with the UK IPO. And we have taken steps to make financial institutions and our government banking institutions, financial institutions, be aware of this law and how to implement this. The biggest challenge really is valuation, because not everyone is equipped to value their IP. We don't have yet a standard way of putting a number to an IP. Kasi that's the problem, diba? If you're gonna mortgage your land or your house, we have a fair market value for that, and the financial institutions have a reference point on how much they can lend money to you, because they know that they can recover their money if in case of default. They could apply your real property. But for IP, the challenge is how do you really measure the value of an IP? So that's something that we need to develop further, and we need banking and financial institutions comfortable with, to to accept whatever valuation or whatever value that a third party IP valuator will put to an IP. Once we have that system, I think it's gonna be easier. Director Cuyo, maybe IPO Phil also has some inputs on that.
Director Cuyo, any additional inputs?
Yeah, I was actually part of the technical working group that worked on the PPSA, and really the challenge in terms of using IP as a collateral or security for your loans would be on the part of the banks, the valuation. So I agree with EJ, that's the first hurdle, I think, to have a standard system like they have in other countries, in other jurisdictions, to valuing IP that is acceptable to our bankers and financiers.
Thank you, Director Cuyo. Okay, so what can be done to make these creative industries more coherent or unified? Yeah, there are so many sectors in the creative industry. Any programs to address this seemingly lack of unity on the different sectors? Perhaps the Bureau of Copyright can help in making the industry more coherent and unified.
Yes, thank you very much, Wina. I think that's one of the objectives of the summit that we first held last year, the International Copyright Summit, because we found out that somehow all you need to do is just to give creatives an opportunity from belonging to one industry to meet with their counterparts in other industries. So, for example, those in music meeting those in the publishing and literary field. So that's one. And I think the other thing that can be done, and as discussed by Congressman De Venecia, would actually be the creation of a creative industries council that we put together and will be focused on the development of the creative industry.
Thank you, Director Cuyo. EJ, any inputs regarding the sector being not united or coherent?
Yeah, that has been identified as an issue. If we want to be the next Korea or the next Japan, we really need to support all our creative industries. And I was really hopeful that the bill of Congressman De Venecia will get passed, because I think that will address so many gaps in our IP system, and hopefully that will also address the gaps in the creative economy sector.
Okay, so any questions from our physical audience? Okay, they're probably listening very intently and absorbing and really interested with what EJ and Director Cuyo has to say. Okay, we have time for one last question. I'm not sure if Director Cuyo is in the position to answer this, but will the Philippines be able to launch a policy guideline on GI or geographical indications this June as scheduled?
I think just to quickly answer that, but it's another bureau that handles geographical indications. It's our Bureau of Trademark. But I think 2 weeks ago, they actually have a consultation on the proposed policy guidelines regarding geographical indications. So I think it's already in the pipeline. We just need to get your comments, your suggestions, and recommendations.
Okay, so to our audience who are interested in geographical indications, please feel free to reach out to the IPO for further details. Okay, time flies when we're having fun. We have so many questions, but because of the limited time, we will just relay them to our speakers and hopefully request their indulgence to please take them offline. I would like to thank again our speakers, Attorney EJ Baranda and Director Cuyo, for a very meaningful and interactive exchange. So as we close this event, we'd also like to thank the Southeast Asia IP SME Help Desk for their support for the event and continued collaboration with the Chamber. And to our physical audience, thank you very much for coming over, for being brave enough to join us here today. To our virtual audience also, thank you for your active participation. On behalf of the ECCP team, and as our final note, we like to take this opportunity to invite you to join us at our upcoming events, and details will be flashed as we close the session. Thank you very much. Good afternoon.
Thank you. Thank you. Bye.
Thank you.
Did you know that small and medium-sized enterprises represent 99% of all businesses in the EU and account for 70% of all jobs? Close to 45% of GDP in the EU was generated by IPR-intensive industries. SMEs are the motor of the EU economy. Their potential to boost employment and drive future innovation, two key priorities for the European Union, should not be overlooked. SMEs are particularly present in innovative industries such as clean technologies, healthcare, ICT, etc. Today, more and more SMEs are looking for business opportunities in emerging markets. Many of those companies are considering China, Southeast Asia, and Latin America as potential destinations. Trade relations between the EU and emerging markets have taken a new turn with the ongoing negotiation of FTAs and investment agreements. These regions are attractive destinations for European investors, with their fast-growing markets, rising middle classes, and competitiveness. Due to limited resources and available capacity, SMEs face many difficulties in managing their IP assets, and particularly when this involves IPR infringement in other regions. Intangible assets such as intellectual property rights are key factors in the competitiveness of businesses in the global economy. We have to be aware that IPR-intensive industries contributed 86% of imports and 93% of exports to EU external trade. And in developing markets such as Southeast Asia, Latin American countries and China, your trademark, patent, trade secret, industrial design are endangered. Before internationalizing your business, take an active part in protecting your assets. The International IPR SME Help Desks are here to assist you and contribute to SMEs' internationalization by the provision of step-by-step advice to build a successful IPR strategy for entering into the Chinese, Southeast Asian and/or Latin American markets. The range of services offered by the Help Desk includes a 24-hour helpline service to reply to IPR questions, free online and on-site trainings delivered by IPR experts, free publications on various IPR topics and country fact sheets, and other useful information forms such as case studies, e-learning modules, video podcasts, and more. So if you have any inquiries on IP protection, contact the Help Desk in China, SEA, or Latin America to learn how to manage your IP assets and expand your business successfully.